A former president of the United States was supposed to walk into a courtroom and face a judge. Instead, his attorneys walked in with a message. He couldn't appear. A sudden health issue, they said, made it impossible. And just like that, the entire proceeding shifted. But inside that courtroom, the response wasn't sympathy. It wasn't outrage either. It was something far more serious. The judge didn't explode. The judge didn't accuse. The judge demanded proof, documentation, timelines, sworn verification. Because in a high-stakes legal battle, especially one involving a former president, nothing moves without a record. And the court made it clear, last-minute medical claims don't automatically stop the machinery of justice. Now here's where the tension snaps tight. If the health issue is legitimate and properly documented, then this is about constitutional fairness, the right of any defendant to be present, prepared, and medically able to participate in their own defense. But if the timing raises questions, if the paperwork doesn't match the urgency, if the details don't line up with prior scheduling fights, that changes everything. This isn't just about one missed appearance. It's about credibility in a courtroom already packed with history, politics, and pressure. On one side, Trump's legal team invoking medical necessity and privacy. On the other, a judge insisting on procedural accountability on the record. And what happens next, whether sealed medical documents are submitted, whether deadlines shift, whether the court issues a written order, could ripple far beyond a single hearing. So what exactly was said inside that courtroom? What did the judge put on the record? And why are legal analysts quietly warning that this moment could either safeguard Trump's legal rights or seriously undermine his standing before the court? Because the next filing deadline may determine which version of this story survives. Here is the central claim driving this entire controversy, and it's far more precise than the viral headlines suggest. During a scheduled court proceeding in one of Donald Trump's active legal cases, verify, specify exact case, court, and date, his legal team informed the court that a sudden health-related issue would affect his availability to appear or proceed as planned. That announcement alone was enough to halt the rhythm of the hearing. But what happened next is where this story turns. According to reports from inside the courtroom and any available transcript or minute order, verify exact language from transcript or written order, the presiding judge did not simply grant an open-ended delay. Instead, the court indicated that any adjournment based on medical grounds would require formal substantiation, documentation, clarification of necessity, and potentially sworn verification outlining the nature of the limitation and its expected duration. That response is critical because despite how explosive the headlines sound, this is not unprecedented. Courts across the country routinely require documentation when attorneys cite medical issues to postpone hearings, depositions, sentencing dates, or trials. Especially in high-profile or time-sensitive matters, judges are obligated to build a clear record explaining why the calendar is being altered. So why did this moment ignite such intense reaction? Because of the broader context surrounding it. Multiple overlapping criminal and civil proceedings, compressed legal timelines, intense national scrutiny, and prior disputes between the parties over delays and scheduling. Verify specific prior motions in this case. That context amplifies everything. But let's be precise about the headline. It is not, "A judge proves a lie." The headline is this: a judge signaled, clearly and on the record, that health-based postponements in a former president's case would be scrutinized carefully, formally, and according to standard evidentiary procedure before the court's calendar is moved. And that distinction matters more than the viral framing ever could, because now the central question isn't political. It's procedural. When health is invoked in a courtroom, especially at the highest level, what evidence is required, and who decides when that evidence is enough? To understand why this moment carries so much weight, we have to zoom out, way out. Donald Trump is not facing a single isolated legal dispute. He is simultaneously navigating multiple proceedings across different jurisdictions, each operating under its own rules, deadlines, and judicial oversight. At the federal level, he has faced charges related to alleged efforts to overturn the 2020 election results, brought by special counsel Jack Smith in Washington, D.C., verify current status and posture of that case. In a separate federal matter in Florida, he was charged in connection with the retention of classified documents at Mar-a-Lago. Verify procedural posture and any recent rulings. At the state level, prosecutors in Georgia brought racketeering-related charges tied to alleged election interference. Verify status, co-defendants, and scheduling posture. And in New York, Trump has been entangled in both criminal and civil proceedings, including the Manhattan criminal case related to hush money payments, verify current status, and the New York civil fraud case brought by the Attorney General, which resulted in significant financial penalties and ongoing appellate battles. Verify judgment and appeal status. Each of these cases operates independently. Different judges, different procedural calendars, different evidentiary standards, different political and legal implications. And in high-profile litigation, especially involving a former president who is also an active political candidate, scheduling conflicts are almost inevitable. Defendants frequently request continuances, remote appearances, modified testimony schedules, sealed medical submissions to protect privacy. There is nothing inherently suspicious about a health-related request. Courts handle them every day. But here's where tension begins to build. In several of these cases, Trump's legal team has aggressively challenged the timing of proceedings, arguing at various points that trial dates were rushed, politically influenced, or constitutionally problematic. Verify specific motions to dismiss or delay in each relevant case. Prosecutors, in contrast, have often argued that extended delays risk witness availability, fading memories, and the public's interest in timely justice. Verify prosecution filings referencing prejudice or delay. So when a sudden medical issue intersects with an already contested calendar, it doesn't land in neutral territory. It lands in courtrooms where judges have already ruled on scheduling disputes, deadlines have already been negotiated or imposed, appeals may already be underway. Which brings us to the immediate, unavoidable question. Is this a legitimate health matter requiring reasonable accommodation? Or does it function, intentionally or not, within a broader pattern of procedural delay? And more importantly, what evidence exists to support either interpretation? Because the answer to that question determines whether this moment is routine or pivotal. And to see how we reach this flashpoint, we need to rewind the timeline. Weeks before the disputed court date, tensions were already building inside this case. The docket shows a pattern of procedural friction, motions filed, deadlines debated, calendars contested. Verify. Insert specific motion to delay, motion to dismiss, or scheduling dispute in the relevant case. The court had already established a structured timeline, deadlines for pretrial motions, discovery exchanges and disputes, witness disclosures, and potentially even a projected trial window. Verify exact scheduling order. Trump's legal team had previously argued that certain deadlines were too compressed, that they imposed an unfair burden, limited adequate preparation time, or raised constitutional concerns. Verify specific arguments from filings. Prosecutors pushed back. In their responses, they argued that additional delay could undermine the integrity of the proceedings, citing concerns about witness availability, evidentiary clarity, and the public's interest in timely resolution. Verify prosecution language. So by the time the contested hearing date arrived, this was not a neutral calendar slot. It was part of an already strained procedural tug-of-war. Then came the pivotal moment. According to court records and reporting from the proceeding, Verify transcript or minute order, Trump's attorneys informed the court that a sudden health issue would affect his ability to move forward as scheduled. Immediately, critical questions surfaced. Was hospitalization involved? Verify. Was this a short-term condition or something more serious? Did physicians recommend full rest or limited activity? Could he participate remotely? Were sealed medical documents submitted to support the request? In response, the judge reportedly required formal substantiation, potentially including medical documentation filed under seal. Verify exact language from court order. And here's what legal analysts quietly emphasized. The judge did not reject the health claim outright, but neither did the court grant an automatic, open-ended postponement. Instead, the issue was framed in procedural terms. When a party seeks delay for medical reasons, the court must evaluate necessity, duration, and impact on the proceedings. That evaluation typically requires written physician statements, projected recovery timelines, clear explanation of functional limitations. Then the public narrative exploded. Commentators began speculating, and without access to sealed records, about motive and timing. But speculation is not evidence. The real story lies in what the judge required and how the legal standards were applied. Because what came next in the court's own language may have raised the stakes even higher. Controversy is not a tweet, not a cable news chyron, not anonymous commentary. It's the court's response. Because in American law, the only words that truly matter are the ones entered into the record. According to the available reporting and any transcript or written order issued in this proceeding, verify. Insert direct quotation from the judge's oral ruling or written minute order. The court made clear that any request to adjourn based on medical necessity would require substantiation. If the judge used phrases such as specific medical documentation, sworn verification, or evidence sufficient to justify adjournment, that wording is not cosmetic. It's procedural muscle. Courts operate on documented necessity, not public claims, not press statements, not implication. And this is where the contrast becomes critical. Trump's team's position, as reported or reflected in filings, can be summarized this way. A legitimate health issue arose. It materially affected the defendant's ability to appear or proceed. He is entitled, like any defendant, to reasonable accommodation. And medical privacy limits what can be disclosed publicly. That argument is grounded in real constitutional principles: the right to be present, the right to assist in one's defense, the right to medical privacy. Now contrast that with the court's procedural stance. Any adjournment must be justified on the record. The court has a duty to protect the integrity of the schedule. Opposing parties have the right to test and challenge the basis for delay. Those are not political positions. They are structural obligations. If sealed medical documentation was submitted to the judge, the public may never see it. That does not imply fabrication. It reflects standard judicial practice when sensitive health information is involved. But here's where the tension sharpens. If the documentation is detailed, specific, and medically grounded, the matter likely resolves quietly. The schedule adjusts, the docket moves on. If the documentation is vague, incomplete, or inconsistent with the scope of the requested delay, that creates a different kind of problem. Not a headline problem, a credibility problem. And we need to draw an important line here. As of this moment, there is no public judicial finding that any medical condition was fabricated. Verify that no such finding exists in the record. Judicial skepticism, if expressed, is not the same as an accusation of lying. Judges routinely demand clarification before granting procedural relief. In fact, precedent supports exactly this approach. Courts across jurisdictions require documentation when sentencing hearings are postponed due to illness, trial testimony is delayed, defendants request medical furloughs, civil litigants seek continuances based on health concerns. The standard question is always the same. Is the claimed limitation genuine, documented, and materially connected to the inability to proceed? If the judge required detailed proof here, that is not extraordinary. In high-stakes litigation, especially involving a former president, it may be inevitable, but this is where the stakes reach their highest point. If the court ultimately finds the documentation sufficient, this chapter closes quietly. If not, the judge has options. The court could deny postponement, limit the delay to a narrow window, require live or in-camera physician testimony, or issue findings that affect how future requests are evaluated. And in a courtroom, credibility is currency. Once strained, it doesn't just affect one hearing. It shadows every motion that follows, every request for time, every claim of burden, every appeal to fairness, which means the real story isn't the announcement of a health issue. It's what the court ultimately accepts or refuses to accept as proof. And that determination may shape everything that comes next. Here's where the complication sets in. The public reaction was instant and explosive. Headlines blared phrases like game over, caught, exposed. Social media turned a procedural exchange into a verdict. But legally, that conclusion is premature. Unless a judge explicitly finds bad faith, and as of now there is no public ruling declaring fabrication, verify current record. There has been no judicial determination that any health claim was false. And that distinction matters. At the same time, the court's insistence on substantiation sends its own signal. Judges routinely rely on representations made by counsel. The fact that this judge required documentation suggests a refusal to rely solely on verbal assurances in a case of this magnitude. That creates tension in two directions. If the medical documentation is detailed, medically grounded, and consistent with the requested delay, then critics who rush to declare deception may look reckless. But if the documentation proves vague, inconsistent, or insufficient, the reputational consequences for the defense could extend far beyond a single hearing. Meanwhile, prosecutors may argue, as they have in prior scheduling disputes, verify filings, that repeated delays, regardless of cause, impact witness availability, jury memory, and public confidence in timely justice. In election season cases, they may also raise concerns about compressed political timelines, verify applicability to this case. And here's where the contradiction sharpens. Trump has frequently argued that the legal system is biased against him. Yet in this moment, the judge's demand for documentation can just as easily be framed as neutral judicial gatekeeping, applying the same evidentiary standards that would apply to any litigant. So which is it? Judicial overreach or routine enforcement of procedural norms? The answer may hinge entirely on filings the public hasn't seen. And that uncertainty is exactly what keeps the stakes so high. A credible analysis has to do something many viral headlines refuse to do: steelman Trump's position. Start with the Constitution. The Sixth Amendment guarantees a defendant the right to be present at critical stages of proceedings and to participate meaningfully in their own defense. If a genuine medical condition interferes with that ability, whether temporarily or more seriously, courts are not just permitted to accommodate it. In many instances, they are required to. Second, privacy matters. Medical records are among the most sensitive documents in existence. Courts routinely allow sealed submissions specifically to prevent the public disclosure of diagnoses, medications, or physician assessments that have nothing to do with guilt or innocence. In a case involving a former president and active political candidate, the risk of political weaponization is exponentially higher. Sealing medical documentation, if it occurred, would not be unusual. It would be standard judicial practice. Third, the burdens on high-profile defendants are not theoretical. Campaign travel, security logistics, constant media scrutiny, and Secret Service coordination can complicate even minor health issues. Legal experts have noted in other high-profile cases, verify comparable expert commentary, that stress and logistical constraints can meaningfully affect recovery timelines. Fourth, and perhaps most important, timing alone does not prove strategy. Illness does not consult the court calendar. Legal commentators consistently caution against assuming bad faith without evidence. And unless a judge explicitly finds misconduct, the legal presumption remains neutral. So it is entirely plausible that a legitimate medical issue arose. Documentation was properly submitted under seal, and the court is simply performing routine verification. If that's true, this becomes a story about judicial diligence, not deception. But the final answer depends on what the court ultimately rules. And that ruling may shape public perception in ways that extend far beyond this single hearing. This isn't just about one defendant, and it's not just about one hearing. It's about how the American legal system handles power, pressure, and procedure when all three collide at once. At the heart of this moment is a balancing act that affects everyone, not just Donald Trump. Courts must constantly weigh medical privacy, procedural fairness, timely justice, public transparency. Lean too far in one direction, and you create risk. If courts accept unverified claims without documentation, proceedings can be delayed strategically. Deadlines lose meaning. Public confidence erodes. Future litigants, powerful or not, may test how far they can push the calendar. But lean too far the other way and something equally dangerous happens. If courts dismiss or minimize legitimate health concerns in the name of speed, constitutional rights are threatened. The right to be present, the right to assist in one's defense, the right to fair process. The standard applied in moments like this doesn't disappear after one ruling. It becomes part of the courtroom culture. Especially in cases involving powerful political figures, judges know their decisions will echo. And then there's public trust. If supporters believe judges are hostile or politically motivated, trust in the judiciary declines. If critics believe courts are being manipulated or gamed through delay tactics, trust declines just as fast. Either perception chips away at something foundational, the idea that justice operates on rules, not personalities, and we can't ignore timing. When election cycles overlap with criminal or civil proceedings, even routine scheduling decisions take on amplified political significance. A delayed hearing isn't just a delayed hearing. It can affect campaign narratives, media cycles, and voter perception. That's why when a judge demands documentation, it isn't theatrics. It's an attempt to maintain equilibrium, to create a record strong enough to withstand scrutiny from both sides. And however this specific dispute resolves, the ripple effects may influence how future high-profile defendants, Republican, Democrat, or otherwise, invoke medical necessity in court. Because once a standard is set at this level, it rarely stays confined to a single case. Now everything turns on what happens next. Will the court formally accept the submitted medical documentation, if it has been submitted? Will any records remain sealed, shielded from public view? Will prosecutors challenge the sufficiency of the proof? Will the current deadlines shift? Or will the court hold the calendar exactly where it is? The answer isn't coming from cable news panels. It's coming from the docket. Watch the next filing date. Verify specific upcoming deadline or status conference. Because that single entry, a brief order, a minute notation, a sealed attachment, could quietly resolve this dispute or trigger an entirely new procedural clash. If the judge issues a written order clarifying findings, every word will matter. Did the court find good cause for delay? Did it narrowly tailor the postponement to a defined medical window? Did it require additional documentation? Did it caution against unsupported future requests? Those details won't just settle a scheduling question. They will shape the credibility landscape of this case moving forward. And here's the part most casual observers miss. The most consequential developments in major legal battles rarely happen during dramatic in-court exchanges. They happen in dense technical written orders, 5, 10, sometimes 20 pages long, that almost no one reads in full. But inside those pages, the judge answers the question that truly matters. Was this a routine act of judicial oversight? Or was it a credibility-defining moment that will echo through every future motion? The next procedural move could affect not just this case, but others where timing, presence, and delay are already contested. So if you want the real story, don't just watch the headlines, watch the filings. Subscribe, follow this series, and stay locked in. Because when that next order drops, we're going to break down every line, every implication, every signal the court sends. In high-stakes litigation, it's rarely the loudest headline that changes everything. It's the next sentence in the court order, and that sentence may be coming sooner than anyone expects.